Here we go. We will go on the record in the matter 21 CM 224, 21 CF 178, State of Wisconsin versus Brad Kent. We have both a Washburn County case as well as a Burnett County case in which the court is doing a sentencing hearing after revocation. This court was assigned the Washburn County case.
This isn't just a routine sentencing. This is a case where addiction, repeated second chances, and a controversial theft collide in a courtroom showdown. 2 counties, multiple offenses, and a defendant who had every opportunity to turn things around, but didn't. At the center, a bizarre but serious crime: stealing birch trees from public land to resell for profit. Sounds unusual, but the consequences are anything but. Now, after probation failures and relapse, the court must decide, is this a case for rehabilitation?
For efficiency of the court as well as ease of the parties, we do have appearing in the Burnett County Court in person, Mr. Kent in custody, Joel Feliski, defense counsel, District Attorney Kevin Schmidt for the Burnett County case. We also have appearing by video conferencing, Aaron Marco for the Washburn County case. Mr. Kent, you're here for a sentencing hearing after revocation. As you can see, Mr. Marco, the Washburn County prosecutor, is appearing to your left on that big screen. Are you okay with him appearing by video conferencing?
Yes.
Okay. If at any time you can't hear him or see him, first talk to your attorney, but then let me know so I can make sure you've heard and you understood everything, okay?
Okay.
All right. So we're here for the sentencing hearing after revocation. The court has received and reviewed the joint revocation packet, order, and warrant. I'm going to start with Mr. Schmidt on the misdemeanor matter. Did you receive a copy of the revocation order and warrant?
I've received it. I reviewed it. I have what I think is a correction. On page 20, for financial obligations for our case, it writes an agent comp. In the 21 CM 224 Burnett County case, it says Mr. Kent did not make any payments towards this obligation. And then on the last page where it shows like the actual balance inquiry, it shows he paid $970. I think the $970 is likely the accurate thing, and the other thing was probably copy paste. That's all.
All right. Okay. Thank you. Mr. Marco, did you receive a copy of the joint revocation order and warrant packet?
I have. I've reviewed it and I've spoken with Mr. Schmidt about it, and the correction that he made is the only thing that I saw that required any attention.
All right, thank you. Mr. Feliski, did you receive a copy of that?
I did, Your Honor. I did review a copy of that with my client. We don't have any corrections to make of it.
All right, thank you. I'm going to, this is a joint sentencing hearing, but I'm going to start with Burnett County case, the 21 CM 224, the misdemeanor matter. Mr. Schmidt, argument and sentencing recommendation, and are we in victims' rights compliance?
We're in victim rights compliance.
All right, argument.
DOC recommends between 6 and 9 months on both the theft and the crim damage. The state is going to be arguing for 6 months. The state's going to be arguing they should be concurrent to each other because the criminal damage to the trees was necessarily part of the theft of the trees. This was the case with the stealing of the birch trees for purposes of reselling. The state's going to be asking for this to be consecutive to Washburn's case because they're different counties in different cases. I think 6 months is appropriate because while this defendant does have criminal history, aside from the birch theft here and what appears to be another birch theft in Washburn that happened in the same time frame, his only other history involving stealing appears to be from 2008 with a theft in Washburn County. I think with the theft here, it's hard to say what sort of penalty would be appropriate for stealing that kind of property. The entity that was harmed was kind of the public in a way because it was taken off of public land. So it's really for the public's benefit and for conservation purposes and making sure we have enough through like seeding and public enjoyment through that, which is different from, say, other cases where we have an individual victim in the community where the theft also necessarily entails, you know, taking away someone's more privacy rights, taking away their rights of safety with themselves and their property. So to the one extent, the victim being the government is both an exacerbating thing and a mitigating thing, depending on how you look at it. He did make some payments on restitution during supervision, which is a positive. $970 encompasses about 34% of the amount missing. It's probably not positive that is how much that was paid over 4 years, which encompasses less than $250 a year. The basis for revocation can be something that increases or decreases the penalty a person would get. The sentence the court's supposed to do today is the sentence the court would have done back then, mitigating upwards or downwards based on supervision. I don't think the court would use anything about his performance on supervision listed in the violations to ratchet it up or downwards in terms of he had use violations, he failed the Washburn drug court. I think what the court probably would weigh against him would be over 4 years, he only paid $970, which also necessarily required the court to extend his probation, I'm guessing twice from, if I recall correctly. So for that reason, I do think that the jail is merited in the amount of 6 months, which is quite a lot if you look at it in terms of the last theft being 2008, but not a lot if you consider that the victim still hasn't been made whole 4 years later, that he was sentenced around the same time for a similar type of theft in another county. I think those are things that merit the 6 months. I think it should be consecutive because it is a different entity that was harmed. These are different governmental entities that were harmed between Washburn and Burnett County. And I think it would depreciate the seriousness of the offense to try to collapse those into one conviction as DOC is recommending. They recommend running the 1 year in Washburn concurrent to the 6 to 9 months in Burnett County. For sentence credit.
Consecutive.
What?
I thought it said consecutive.
Let me just double check.
In review of the packet, Your Honor, the language, I believe it's just form language, says this recommendation is consecutive to following cases and counts, and the department marked none.
Oh, I didn't see the none. Sorry. Okay,
Yeah.
Sounds good.
I read it as all concurrent.
Okay.
And then finally for sentence credit, I came up with, he had 46 days that was exclusively Burnett credit. He had 53 days that were exclusively Washburn credit. And he had 125 days, not counting today, that were exclusively, that was both cases credit. Meaning if the court ran it concurrent as DOC recommended, he'd have 169 days credit in the Burnett case and 178 days credit in the Washburn case. If the court ran it consecutive, he'd have 222 days credit, putting them together but not double counting. Thank you.
All right. Okay. Thank you. Mr. Marco.
Thank you. Looking at Mr. Kent's criminal history, he does have a couple of possession of meth convictions in 18 and 17, disorderly in 17, criminal damage to property in 16, and a paraphernalia, another paraphernalia in 11, Omvok in 09, and the theft that Attorney Schmidt had mentioned in 08. So it's not, it's definitely not the most substantial criminal history that we've ever heard, but it's nothing to not pay any attention to either. It is a fairly significant criminal history, especially when we look at the underlying, what my understanding of the underlying incentive for engaging in the birch theft was in the beginning. In Washburn County, as the court will note, it was a conspiracy charge that was originally charged out. There was a group of individuals that were out stealing birch poles on county land. They had a fairly sophisticated system that they were operating in an attempt to to acquire these and to resell them, as they're very commonly used in Christmas decorations and outdoorsy type of things that are very common in the Northwoods as far as decor and home decor, that type of stuff goes. I have a little bit of an advantage, I would think, in this particular case, for knowing Mr. Kent, coming through the Washburn County Drug Court that I am a participant of. Mr. Kent has the ability to do very well when he wants to. He can succeed. He can maintain sobriety. He's done it a couple of times in his life. He's been able to get his children back. And he was actually at a point where that was going to be full time in this case. And then he started to slip up again. He started to associate with individuals that were not in his best interest, and that ended up getting him in trouble again. Particularly one of them was Melissia Dollar, which was an individual that he had brought back into his life. And over the objection of the drug court team, he decided to move her and her child into the house. And it didn't take long before that relationship turned into him being referred for new charges, including possession of a firearm by a felon. It was a unique case. In that particular instance, there was a lack of evidence. There was also Miss Dollar, who was the primary witness, had lied to law enforcement, was being untruthful in her statements to the Department of Corrections, and some things sort of looked like she was setting Mr. Kent up. Now, that being said, he was given another opportunity in drug court to continue in the program and recover. He went back. He had acquired a very good job at Paragon in the Spooner area. He was living at the Compassion Connection, and he was involved in inpatient treatment and was doing very well. Unfortunately, him and another individual from the center decided to stop and have some beers. Eventually, they came out with the entire truth, and methamphetamine was involved again, and that resulted in his removal from the drug court, as well as the revocation proceedings that we have here today. Looking at the reasons that we're here because Mr. Kent has uncontrolled methamphetamine addiction issues is the primary reason. Whether that's because he chooses to not exercise sufficient control over them, or he hasn't learned the right coping skills, whatever it is, the truth is that we're here because he continues to relapse and is not able to control his methamphetamine addiction. That, I believe, is the same addiction that was underlying the theft. And when you look at the theft of the birch poles, that's been a fairly common problem amongst northern Wisconsin. Burnett County has the same problem that we do in Washburn County. Sawyer County has it as well. It's kind of a unique issue, but it is something that is affecting a lot of people, the public and private citizens. In this particular case, it was public land that these matters were stolen from. And in our case, I think they started collecting the restitution and applying that to Burnett County, because I didn't see where it had indicated much of anything was paid as far as restitution goes in the Washburn County case. So this is a serious offense. He does have rehabilitative needs, and there is a need to protect the public, not just from stealing trees out of the forest when there's nobody there either, but as you can see from the allegations with the OWI and the other things that have been going on, when you look at the behavior and the rehabilitative needs of Mr. Kent, the facts underlying his behavior, which is his meth addiction, put the community in danger. When he's actively using, the community is in danger. And like I said, I've known Mr. Kent for a long time. Personally, I think he's a nice guy. I think he's a good guy. I think he's got a kind heart. He tries to do the right thing, but he has an addiction that is out of control, and he cannot maintain himself in the community at this point in time. It's an unfortunate fact, but it's a fact nonetheless. Looking at the jail credit, I believe in the 178 case that he has 178 days credit. Attorney Schmidt and I looked, I think if the 125 days that's applied to both cases plus 46 gives him 171 days credit in the Burnett County cases. Of course, I think I originally read the sentencing after revocation packet like the court did. I originally thought that it was consecutive until a closer reading when I saw what Mr. Feliski had pointed out, that it was just worded kind of awkwardly. So my recommendation for the Washburn County case is 1 year in the county jail with credit for 178 days and financial obligations to be reduced to civil judgment.
All right, thank you. Mr. Felisky, argument on both cases.
Thank you, Your Honor. I think looking at the core issue here, the reason that we are, the central reason why we are here before the court today, why Mr. Kent came before the court on this sentencing after revocation for these cases, is the issue of substance use. All the parties, I think, are in agreement that Mr. Kent has an addiction problem. He has a methamphetamine issue. He has made efforts and has succeeded in the past in addressing this issue. But perhaps more importantly, and not to bury the lead here, I guess, so to speak, there's an issue with relapse. From reviewing the packet, reviewing the criminal history, the prior history, speaking with Mr. Kent, it seems that there is a pattern that begins to unfold. He relapses, feels intense guilt, shame, an inability to speak with others and to address head on this issue, this relapse, and from there begins to spiral out. I don't believe nor offer that as an excuse, Your Honor, but simply to contextualize what I think is happening here, which is that there is a substance use issue, and coincidental with that issue is an ability to reach out to make use of the resources that are available to him to address this specific concern. Reviewing the sentencing memorandum that was submitted to the court here, what struck me was that it seems that very unfortunately, there was an issue with the therapist that was sitting on the drug court with Mr. Kent and working alongside and with him. It seems that there was some concerns there, and I'm not saying that they are I wouldn't say that those concerns are necessarily overwhelming or overriding in this circumstance, but there were concerns regarding transparency, being able to speak in confidence with a therapist in these circumstances. It's certainly regrettable, and I think Mr. Kent has made very clear going forward that he is going to be fully engaging in services to avoid having this situation come up again. Looking again over the credit here, Your Honor, I do note that Mr. Kent has spent a significant amount of time already on these cases in custody. He's had 85 days up to today's date to consider what led him to this point and what he needs to do going forward. To that effect, Your Honor, it seems that he does have a solid post-release plan that's available to him, once he is released on this matter. He does intend to engage with follow-through regarding psychotherapy, mental health, and substance use assistance through Aurora. My understanding that he's been working with the social worker on the issue of reunification with his children. I believe his partner is scheduled to be released from prison shortly and will be able to help facilitate that. Perhaps most importantly, Your Honor, Mr. Kent is looking very strongly at the issue of health insurance. It seems that there were some ongoing issues regarding not perhaps substance use per se, but the use of medication in assistance with his recovery.
Who's his partner? Who's going to be released from prison?
It's my kids' mom, so she could like help me with the kids. So because like I was just doing everything myself, you know, trying to get the kids out of social services, trying to hold down a job, trying to take care of the place by myself. Like, to be honest with you, it just got to be a lot, you know.
You'll get a time to say.
Right.
I just wanted to know who it was. And so are you in a significant relationship with her?
No, she's just my kids' mom. But
Okay.
she's gonna help, like she could be like a co-parent with me, you know, instead
Okay.
of me just doing it by myself.
Mr. Felisky.
Thank you, Your Honor. To pick up where I left off, to go off on some of those comments, actually, I think the main issue here for Brad, once he does get out of custody, is understanding that he can't have the weight of the world on his shoulders. He can't face these issues alone. He can't deal with this ongoing issue with addiction, relapse alone. I think the time in custody has helped him to understand that, to internalize that, and to understand that he does need to engage and use these resources and be active in using these resources if he wants to avoid appearing before the court in Orange ever again. With that in mind, Your Honor, and in consideration of the comments from the state regarding the prepayment, restitution, we would ask for the court to follow the department's recommendation on all three cases, 6 months for the misdemeanors and 1 year in the county jail to run concurrent. Reason for this request being it provides Mr. Kent with a little bit more time to fully establish himself, to iron out all the details of his post-release plan, to have a plan ready and in place for when he does get out, which I think is important here, Your Honor, because again, looking at Mr. Kent, looking at his history, discussing this matter with him, I think the issue truly really is, besides the substance use, that he needs to follow through on what happens when he relapses. Looking at all the facts and circumstances here, what's mentioned in the packet as far as prior violations, again, I see this pattern of he relapses, he gets very concerned, doesn't know who to turn to, doesn't know where to go, and begins to spiral out of control. Under the Galleon factors, Your Honor, I think the recommendation made here would be appropriate. It would continue to protect the community. It would provide additional time for Mr. Kent to spend thinking over what he needs to do to access what resources are available at the jail to help facilitate, again, that post-release plan. I think that the length here is appropriate given what's alleged here, or given the nature, I should say, of the offenses that he was convicted on here. And I think this additional time will prove helpful for him to, again, understand what he's done, what he needs to do, what he has been doing, and what he needs to do going forward. Thank you.
All right, thank you. Mr. Kent, anything you want to let me know, you want to tell me?
I just want to apologize for the poor choices that I made and the people that it affected.
Slow down.
I just want to apologize for the poor choices that I made and the people that it affected.
I appreciate that. I remember this case, even though it was a 2021 case, because it did involve those birch trees and the taking of the Burnett County forest. And now I've been assigned, just for sentencing purposes, the Washburn County, which is pretty much the same case, except it appears from the information that I have that the Washburn County matter involved a lot more taking of the birch.
Okay.
So that's why that was a felony and this is a misdemeanor. Now, I have to look at the seriousness of the crime, all the Galleon factors that your attorney went over, the seriousness, your character, your past criminal record. I have to look at the rehabilitation, but now we are beyond the rehabilitation, at least in these cases, because it's the sentencing, it's the punishment part now, because you were put on probation in both counties, you were given an opportunity to rehabilitate or use services and do better. And for whatever reason, but the reasons that are stated in this packet, as well as argued by all counsel, that you failed.
Mm-hmm.
And so you're here in front of the court. This is serious in the fact that it's taking from county resources, and the forests, the county forests are used by the county to generate funds. That's where we get a lot of our money to spend on our programs and our things. They replenish the forest, they grow new trees, then they harvest, then they sell. And again, that's how we get a significant amount of our budget. And Washburn County would be doing the same. I want to see you succeed, and I'm hoping that you're going to figure it out. And I hear you and I understand you when you went on kind of that little bit of a tangent when your attorney was arguing when I asked about who your partner was and that they're getting out of prison soon. It sounds like you had a lot on your shoulders and you were dealing with a lot, and sometimes that gets a bit overwhelming. It's understandable, but if you want to truly get your children back, you're going to have to do better and be better. You're going to have to take control of your life and gain your sobriety and do all of those things that are required of you from whichever county, it's not my county, but whatever county took your children from you. Okay? You have to do that. Otherwise, you're not going to be able to get the kids back in your care and custody. Now, but for the fact that I was assigned for efficiency purposes, the Washburn County case to handle the sentencing, I can't say, or I wouldn't feel necessarily that either prosecutor would ask at that time for a consecutive sentence to anything else. But for the fact that I now have both cases, know both of the facts and those things, then that's where the consecutive comes out. I do understand, and usually I'm definitely the judge that goes different time, different place, different crime, different people, all of those things. If you were in front of me for sentencing at this time, and I have kind of went away from doing withheld sentences in my cases because this type of thing happens and you're in front of the court at a later date. And it's like, look at all these things that he failed at. He didn't do any of these things, so he should be sentenced. But what would I have sentenced at the day of sentencing? That's why I like to do a lot of imposed but stayed sentences. You know what it's going to be, and I have a great idea. I know the facts inside and out, and I know the case a lot better than I know from 2021 to now 2026. I'm now being asked to do a harsher sentence, which would be 1 year and 6 months in the county jail. That's essentially saying, well, you might as well go to prison then for that year and a half and get, you know, other services, other things. In sentencing, in the 21 CM 224 case, the Burnett County case, what I'm going to do is I'm sentencing you to 9 months of incarceration. Okay, 9 months. And in the Washburn County case, I'm sentencing you to 1 year of incarceration. But I am going to give you a benefit, again, even though it's going against what I normally would do in a case. If I were on both of these cases at the same time back then, quite honestly, it'd be a global resolution. And you'd be charged with one and you'd be in front of me for sentencing for one of them. But that's not the case. So I am going to do a concurrent sentence. All right. That still means that you have time to sit in custody. You have time to get your life figured out and have a plan. Look at treatment options and where you can go from there. But I think that if I were to sentence in a consecutive way, even 1 year for the Washburn and 6 months for the other, it would be a harsh sentence, or a harsher sentence than I would have sentenced had I had both of these cases in front of me at the one time. Okay? Even if both of these cases were consolidated and they took the amount that you stole from Burnett and the amount that you stole from Washburn and they put it together, it would be a felony. But here I think was $5,500 or so in restitution for Washburn County, $3,800 or $2,700 and something from Burnett County. And so if you take both of those, that's still, I don't have it in front of me, but that's still less than $10,000, the class I felony that you pled guilty to in Washburn County. So looking at it that way, I would not have sent you to prison for a case like this. I wouldn't have. I would have done a year in custody. Okay. And that's what I'm ordering here today. And that's exactly why I'm doing that. So because it's concurrent, you have 178 days of jail credit. You still have time to sit, a lot of time to think. So figure some stuff out, because if you don't do it and you don't do it now, the more time that goes away, the more time that goes on, the more time away from your children you have, and the more harm and trauma it does to your kids.
All right.
So
All right.
I'd figure it out.
All right.
And I'd stay away from Melissa Dahl.
All right.
Okay?
Yeah.
All right. So you have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. All of the amounts that are owing for the court costs and fees and the restitution are now going to be in a civil judgment. You're always going to owe that. And at least with the Burnett County case, I'm pretty positive that the Washburn County case will be sent right back to Washburn for them to handle restitution. But my case, I come down hard. and I will follow you and you will sit in custody if you don't start making payments and you don't get that paid off, because the county is a victim and the county does deserve to be made whole.
Okay.
Plus the court costs and fees. And perhaps I'd give you a little bit of a deal on the court costs and fees for community service, because then you're giving back, you're learning something, and the community is benefiting. But when you are released from custody, as it relates to the 21 CM 224 Burnett County case, I'm going to be ordering that at minimum you make $100 payments. And I'm going to say that that's going to start, I'm going to say on June 1st, you start making your $100 a month payments. If you don't have a job or you don't have the ability to come up with those funds, you better be writing me, because if I don't know, you will get a warrant, you will sit in custody, and I will hear you as to why, but you could sit up to 6 months in June.
Okay.
Okay?
Yep.
That's on top of all of this. You don't get credit.
Okay.
Okay?
Yeah.
All right. Mr. Schmidt, am I missing anything?
Not for me.
Mr. Marco,
I don't believe so. Thank you.
do either of the clerks need clarification on anything since we are dueling it?
Just that it'll be 178 days credit on ours as well as Burnett's.
Correct.
Okay, sounds good.
All right. All right, then we are adjourned. Thank you.
So this is a year total?
In the end, the judge delivers a decision that tries to walk a fine line between fairness and accountability. Instead of stacking the sentences back to back, which could have meant significantly more time, the court orders them to run concurrently. That means 9 months for one case, 1 year for the other, served at the same time. It's a lighter outcome than it could have been, but still a serious consequence. The message is clear. You were given opportunities, and now it's time to face the result. At the same time, the judge leaves the door open for change, emphasizing rehabilitation, responsibility, and the impact on his children. So now we turn it over to you. Do you think justice was served here? Should the sentence have been harsher or more lenient given the addiction factor? If you found this case as intense and thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.